When we think about the U.S. Constitution, it's easy to picture it as this old, dusty document locked away somewhere. But that's not what it is at all. Really, it's the rulebook for this constant, high-stakes tug of war. On one side, you've got the promise of individual liberty, and on the other, you have the absolute necessity of government power. So today, we're going to break down that fundamental conflict, the one that's really at the heart of American democracy.
And that really brings us to the big question, right? Can a society truly have both? Can you have absolute freedom and perfect order at the same time? Or is there always a trade-off? That's the core tension, the very thing the Constitution was designed to manage.
All right, so let's start with the ideal. Let's talk about the promise that literally fueled a revolution: liberty. This is the foundation of the entire American experiment, this idea that you and I have certain rights that just belong to us no matter what.
And if you want to understand the sheer passion behind this ideal, you just have to look at the words of someone like Thomas Jefferson. This guy was a key architect of American liberty. He swore, and this is a direct quote, eternal hostility against tyranny. He saw this fight for freedom as more than just politics. It was a sacred moral duty. That right there, that's the raw energy pulling on the right side of our tug of war.
Now, this incredible promise wasn't just some vague idea they hoped would stick. No way. It was written down, codified in the Bill of Rights. And you could argue that none of those rights is more central to keeping government power in check than the freedom of speech. Think about it. It's the tool we use to debate, to criticize, and to hold our leaders accountable. It is, quite literally, the engine of a functioning democracy.
Okay, but ideals alone don't run a country, right? For liberty to actually be protected, you need a stable society. And that brings us to the other side of the rope in our tug of war, the practical reality of government power. You have to create a government that can, actually govern. Because a nation can't just be a collection of individuals doing their own thing. It just doesn't work. You need a central authority to handle foreign policy, to manage the economy, to provide for a common defense. And that's exactly why the Constitution isn't just a charter of our rights, it's also a blueprint for power.
A perfect example of this kind of necessary power? Diplomatic immunity. It sounds a little strange, but it exists for a really good reason. It lets our officials do their jobs overseas without being harassed or intimidated by another country's legal system. It's a super practical tool for making sure international relations can happen smoothly.
But here's the thing. This power isn't unchecked. Not at all. Take the process for appointing ambassadors, for example. It's all laid out in Article 2, and it really shows the machinery of government in action. Sure, the president gets to nominate someone, but that power is balanced by the Senate, which has to confirm the choice. It's a system designed to use authority, yeah, but with some really important safeguards built right in.
So, we've got the promise of liberty on one hand and the necessity of power on the other. So, what happens when those two things collide? Well, this is where that tug-of-war gets really intense, and it's usually the courts that have to step in and play referee.
Just take a look at this timeline. It's staggering. For almost 100 years, state power was used to crush the fundamental rights of African Americans. The Supreme Court's decision back in 1896, Plessy v. Ferguson, actually gave constitutional cover to segregation. It took decades and decades of brutal struggle, finally leading to landmark cases like Brown v. Board of Education for that promise of equal protection to even begin to challenge the entrenched power of the states.
And make no mistake, these conflicts are not just ancient history. This cartoon, for instance, powerfully captures the fierce, ongoing battle over abortion rights. You see the landmark 1973 decision, Roe v. Wade, shown as a tree, a symbol of life, of stability, and it's being threatened. This one image just perfectly frames one of the most divisive constitutional debates of our time.
So what was the argument? Well, this quote from Justice Blackmun gets right to the heart of the majority opinion in Roe v. Wade. He grounded the whole decision in a right to privacy, which he argued is implied by the Constitution. He basically said that this fundamental liberty was being trampled on by state power, and that the state's interest just wasn't strong enough to completely take away an individual's right to make such a deeply personal choice.
But then you have the counterargument, and it's just as direct. Justice Scalia's position was rooted in a totally different philosophy, reading the Constitution's original text. And from his perspective, a right to abortion is, well, it's just not there. He argued that if a right isn't spelled out in black and white, then the power to regulate it belongs to the states and the voters, not to federal courts. These two quotes, side by side, show two fundamentally different ways of reading the exact same document.
And this isn't the only place we see this clash. It plays out with the Eighth Amendment, too.
the one about cruel and unusual punishment. On one side, you have the view that cruel and unusual is a living, breathing concept. It has to evolve as our society's standards of decency evolve. But on the other side, you've got the original intent view, which argues it only forbids the specific barbaric punishments that the founders themselves would have considered cruel, like, drawing and quartering. How you answer that question determines everything from the death penalty to the length of prison sentences.
Now, this whole conflict isn't just a historical or theoretical debate. The ultimate stress test for this balance between liberty and power, it almost always comes during a national crisis. And in the 21st century, that test has centered again and again on the response to terrorism. September 11th, 2001. This state, it changed everything. In the wake of those attacks, that rope in our tug-of-war was yanked, and I mean yanked, dramatically in the direction of government power and national security. And that raised some profound, really tough new questions about our civil liberties. One of the most heated issues revolved around this term, enemy combatant. The government's argument was that this designation allowed it to detain people, and yes, that includes U.S. citizens, completely outside the traditional criminal justice system. We're talking no lawyer, no speedy trial, none of the usual rights.
And this is the exact question that went all the way to the Supreme Court. It was in the case of Yasser Hamdi, who was a U.S. citizen captured in Afghanistan. So can the government just label a citizen an enemy combatant and lock them up indefinitely with no charges, no trial? Does the need for national security simply override the most basic rights that come with being a citizen? That was the question.
The Supreme Court's answer, which came from Justice O'Connor, was a massive check on executive power. The ruling was something of a compromise. It said, okay, the government can detain a citizen as an enemy combatant, but it can't just strip them of their core due process rights. The court made it crystal clear, every citizen has to have a meaningful chance to challenge why they're being held.
And this wasn't some new concern that just popped up after 9/11. Decades earlier, Justice Brennan gave this incredibly prescient warning. He totally understood that the argument for military necessity or security is always seductive. It's dangerously flexible and can be stretched to justify almost any attack on liberty. It's a powerful reminder that the courts often have to be that healthy skeptic when the government claims it needs more power.
So what's the takeaway? It's that this tug-of-war, it never, ever ends. From freedom of speech to national security, that balance is constantly being fought over and renegotiated. The Constitution doesn't give us the final answer. What it does is provide the arena for the argument. And that really leaves the final question for you. In this ongoing tug-of-war, where do you stand?